for allowing me the time to educate everyone on how to best protect their brand. Before we get started here, I have to show you my disclaimer. I would not be an attorney if I did not have a disclaimer. And this basically states that what I'm doing today is educating. I am an attorney, but I am not your attorney, just through the mere presentation of protecting your brand. The first thing I would like to address is the common misconception between copyrights and trademarks. Oftentimes, entrepreneurs are trying to educate themselves online, like we all do, and a responsible person does, and they're Googling copyrights and they're getting information and they're becoming confused because it's not the proper thing that they should be looking for. So a copyright protects the things that I have listed here on the screen. It protects writings, a book, a novel, etc., poems, music, plays, movies, dance choreography, and works of art like paintings or sculptures, architectural drawings, and so forth. But it does not protect your brand. A trademark is the proper avenue if you are looking to protect either your logo, your slogan, or your business name. The trademark process in the United States is a two-step process. The first step is to conduct a national search for any potentially conflicting marks. And based on the results of that search, you then determine whether or not it is worthwhile to submit a trademark application. And it's important that everyone knows that the moment you establish for example, a logo, and you submit it to the public, maybe you share it on Facebook with your friends and family. The moment you share the logo with the world, you have automatic, what we call common law protections that attach. So you would have what we refer to automatically as a common law trademark. A common law trademark gives you the right to tell someone else that tries to steal your trademark or steal your logo, or they try to create a logo that is substantially similar to yours, you have the right using the common law trademark to tell them to stop, to cease and desist. So we get to draft a beautifully written legal document with big red bold words in the middle of the page saying cease and desist. If they continue to use that logo anyways, then you have the right to take them to court and a judge will tell them to stop using it. But those are the only rights that you have. In order to go through the court process, you'll have to pay the court fees, you'll have to pay the attorney's fees. The court process, we never know how long that's going to take. It might take 1 year, it might take 3 years, and some of them take many longer than that, much longer than that. And if that person, whomever stole your logo or is using a similar logo, if they take it and they make $500,000 using your logo, you don't see a penny of that. Likewise, if they take your logo and they use it for some really perverted use or inappropriate use, and they run it into the ground such that you can never use that logo again, because now every time the public sees that logo, they think of something inappropriate. Well, now they've ruined what you created. You don't get any compensation for that. So you can take the person to court with your automatic rights, but all the judge will do is tell them to stop. You will never see a penny for the damage that has been done to your business. And so the entire reason we register trademarks, which is what we're talking about today, is to get you those monetary protections that you need. If you have a registered trademark and you have to file a lawsuit against someone because they do not respond to the cease and desist letter, then they'll be responsible for paying the court cost, and they will be responsible for paying your reasonable attorney's fees. And if they made $500,000 using your logo, and of course you'd have to prove that, but if they did, then they have to turn over whatever profit they made using your logo. And likewise, if they ran the logo into the ground and destroyed what you created, then you would receive the reasonable value of whatever it is that they damaged. And so there's some enforcement power or kind of teeth behind a registered trademark, whereas there's not really behind a common law trademark. And the other problem that I see with small business owners is that even if they're relying on that common law trademark, they may go as far as sending a cease and desist letter, but when it if the cease and desist letter is ignored, they don't take the second step to file suit because it's cost prohibitive. It doesn't make sense to do so. And so the small business owners who have been done wrong and suffered some sort of harm end up rebranding their business because it's cheaper for them to rebrand, even though they did nothing wrong, than it is for them to file a lawsuit and wait a couple of years for a judge to tell that person to stop and to come out of pocket all of those attorney's fees, which would be substantial. And I want to point out too, before I move past this slide, you'll see two different marks on the screen. You see the TM on the kind of middle of the page all the way to the right. Oftentimes people will throw that up behind their business name or their logo or slogan, whatever it is. And that stands for, of course, trademark. Anyone can use that symbol. That is the common law trademark symbol. And so you could use that right now. Now, it really doesn't mean anything because everyone that has a brand has a common law trademark. But some people think that by using that TM behind their business name, that it acts as a deterrent, because now I know, and now of course you know too, that everyone has one of those. It's really useless, but there are people out there that may think twice about stealing what you have if you use it behind your brand. And then the actual registered trademark symbol at the top beside the word trademark, the R inside of the circle, the capital R, that is what you use once you have an actual registered trademark. If you do not have a registered trademark through the U.S. Patent and Trademark Office, you cannot use that symbol. All right, to go over the first step in the trademark application process, I want to talk with you about what the trademark search is. It's a search throughout the entire country of the following: a city, county, and state business filings. So we would look at all the city and county business licenses and the Secretary of State, LLCs and corporate formations and all that. We would also look at all trademark registrations and any pending applications through the U.S. Patent and Trademark Office. We would look at websites, and we would also look at social media platforms, Facebook, Twitter, Instagram, and etc., because there's a million of those. After we look at all of those, then we prepare a report, and you go over that report with your attorney, and you make the decision based on that report whether or not it's a good idea for you to go forward with a trademark application. The attorney would be able to tell you, okay, these are the 12 marks, symbols that are similar to yours. And throughout the presentation, you'll hear me say the word mark, and that's just kind of an abbreviated way of saying name, logo, or slogan. So you'll see the attorney would go over the conflicting marks with you, showing you which ones are similar and what ways. And ultimately, the attorney would give you a recommendation on the likelihood of your mark being accepted by the U.S. Patent and Trademark Office, and that's the government agency that issues the registered trademarks. Based on your attorney's recommendations and your own personal preference, you would that's when you would make the decision on whether or not to go forward with the trademark application. And you may decide that there are too many similar marks to yours, that it may be a better idea for you to go back to the drawing board when it comes to your logo name or your slogan. And that is the very reason why the first question an entrepreneur should ask when they're starting their business is, do I need to get a trademark? Oftentimes I find that the first question new business owners or aspiring business owners are asking themselves is, well, do I need to form some sort of entity, an LLC or a C Corp or S Corp, or, the list goes on and on. But that's not the first question. The first question is, do I need a trademark? Does someone else already have a trademark using the business name that I thought of? Because you may very well have to go back to the drawing board and think of a new business name once you learn about all the other ones that are very similar to yours. And I also want to point out that lots of times people think that as long as their logo is not identical to someone else's logo, that there's no conflict there because maybe a word is spelled differently. So for instance, I've literally had people come to my office and say, I'm going to start a coffee shop and I'm going to name it Starbucks, but instead of an S at the end, I'm going to use a Z. And that's still problematic because I've got the standard listed here on the screen. The standard is not, is your mark identical to the other person's? The standard is your mark substantially similar? Would an average person walking down the street look at your symbol and think that it was someone else's? If someone were to try to buy a product that you are selling, would they Google that product and someone else's website pop up and they accidentally purchase from the other person? That's the standard. So it doesn't have to be identical. It just has to be similar, substantially similar. And the last reason why it's important to do a trademark search is to keep yourself from getting in trouble. One of the things that I see devastate new businesses is, they launch their business 3 to 5 years in, they're really picking up traction, they're doing great, everyone in their region knows about them, and life is good. They have finally hit that mark where things are not as hard as they previously were. And then one day they go to the mailbox and they open it up and there's a letter, a cease and desist letter from a small company in a city in Oregon, telling them that they have to immediately stop using their business name because this company in Oregon has been using that same name for 20 years. Well, now the small business owner has knowledge that they are infringing on someone else's rights, and they have to stop immediately. Not next week, not next month when they get around to it. They have to stop immediately. The best practice would be for them to go back inside of their office, pull their website down, or at least erase whatever it is that they're infringing on, the logo, slogan, business name, whatever it is. Remove all mention of that from their website, from their social media. If they have a sign outside that has their logo on it and that's the infringing item, they have to take that down right now, not later, because there will be penalties that will continue to accrue against them because they now have knowledge that they are infringing on someone else's rights. And if they continue to use that logo anyways, they are intentionally and knowingly, willfully infringing on someone else's rights. And so these business owners are devastated, and depending on how well their business is doing, sometimes it can shut the entire business down because they have to right now go hire a graphic designer and design a new logo or come up with a new name. They have to throw away all their business cards, their brochures. They have to get the wrap they got placed on their car removed. And all of those marketing materials cost a lot. Like, those costs really add up. And if you have employees, then they have their own business cards, and maybe you have shirts that your employees wear with the company logo, and you have to replace all of that stuff immediately. And so it can really damage a small business financially. So it's best to do the search in the beginning and get that over with so that you don't run into that brick wall later down the road. These are a few examples that I thought may be helpful of infringement cases that have been on the more popular side here lately. One of them, you'll see the first one here is 7-Eleven versus Super 7. Both of those are convenience stores, and 7-Eleven claimed that Super 7 infringed on their trademark, one, because it sounds very identical and one might confuse those, and also just looking at the images, like, they're not identical, but they are similar. The 11 in 7-Eleven is in the middle of the number 7, and Super is in the middle of the number 7 in theirs, and you all can see the similarities themselves. And then the one below that is Pandora and PayPal. PayPal actually claimed that Pandora was infringing on their trademark rights by the use of the blue P. And that case ultimately settled out of court, as many of these do, and they have these confidential settlement agreements, so we don't actually know what the terms of those settlements are. But we do know that, if you look up Pandora today, they are not using that blue P anymore. Another one here at the bottom is the Exxon versus the FXX, which is, I think that's owned by Fox. Exxon claimed that the double X, the way that they have it designed, was stolen by FX, and they went through litigation, through court on that, and ultimately they settled out of court also. But of course, it's confidential, so we don't know what the settlement terms actually were. Fox they are still using that FXX symbol, and so maybe they paid them some sort of royalty in order to be able to do so, but we really don't know what happened there. And one of the more recent ones, one that I think really hits home with small business owners, is the Forever 21 and the Hustle Kindness issue. Hustle Kindness, as I understand it, is a nonprofit, a small nonprofit in the state of Texas, who holds a trademark to Hustle Kindness. And they sell the t-shirts that you see on the right hand of that picture, I think for about $30, and the profits from those go towards charity to help disabled children and their families. Well, Forever 21, and I think it was this year, posted a very similar shirt on their website for $10. And so it's possible that when people hear about this charity in Texas, that they go to the internet and they type in Hustle Kindness shirt and they purchase it from Forever 21, thinking that the proceeds of the $10 shirt they buy from Forever 21 are going to this charity, but they're not. And of course, Forever 21's website would likely pop up before Hustle Kindness's website. And so there's a whole issue there, and I think that one is still ongoing. But that one should really hit home for small business owners, because
Oops, Amanda, I think we lost you. You just cut out for a second. Hello? Folks on the line, are you able to hear me still? If you could just chat.
So our recording of the webinar cut out during this slide. but the slide contains the most important points about applying for your trademark.
Jewelry, for example, you will need to take pictures of your jewelry if it has a tag on it with a barcode that you would scan when someone tries to purchase it from your store. Well, you need to have a picture of your case of rings that has the with each one of them having a barcode attached to them that you can scan, and that barcode, the tag on the ring would need to have your logo or your name, whatever you're asking for the USPTO to give you a registration in. They want to be able to see overall when you're selling products that you actually are selling them. And so they want to see the barcode, or if you have like a jewelry case and maybe this is your $100 case, then they want to see that you have a sign inside of that case that says $100 for all the items in here, but your logo also needs to be displayed on that sign because they want to see how you're using that mark. If you are selling, also for those of you who sell products online, if for example you sell them on your own website or on Etsy, something like that, you can screenshot a picture of the checkout page, maybe load some items in your cart, a necklace, a ring, and then you go to the checkout page where people can click, buy now, and you screenshot that. But again, that page has to have whatever your mark that you're trying to get protection for on that page. And for those of us who provide services like accountants and lawyers and therapists and those of us business coaches and so forth, if you provide a service, the things that we have to show the USPTO as proof that we're using it is different. We can show our marketing materials. If you have business cards, you can use a picture of your business cards as proof, but your business card, of course, it has to have the mark on it, and it has to kind of describe what you do. So if the name of your business is ABC Consulting, and you're asking for a trademark in the education arena because you're actually an education consultant, well, there's nothing on your business card that says that you deal in the education arena. And so you need to have something on there that says that. If you don't, but you do have brochures that detail your services, a picture of your brochure is sufficient, showing both sides of your brochure where it's talking about your services, and it also has the mark that you're asking for. A picture of a sign outside of your brick and mortar would be sufficient, and so forth. And also for those of us that provide services, a picture of our website is enough, as long as it describes the services that you provide in that picture. So maybe you take a picture of your services page or your about page or something like that. Maybe it's on your home page. Maybe you send in all of those. Most of the time, attorneys will submit multiple examples of how the applicant is using the mark so that we don't face a denial. So that's it for my presentation. Laura, do we have any questions?
Hi there. Sorry, I was muted. I haven't had any questions come in through the chat quite yet, although I see that Bernadette, one of our attendees, has her hand raised. So Bernadette, do you want to chat a question in if there's something on your mind? I'll wait to see that come through.
Okay.
Yeah, otherwise though, I have a couple. So when you were talking at the very beginning about the trademark, the common law trademark versus the registered trademark, have you, and you mentioned that some people feel that the TM is a deterrent to others using their brand. Do you find that that is in fact the case, or would you, recommend that people spend the time and money to get the registered trademark?
I think that it's absolutely worthwhile, necessary to go all the way and get the registered trademark. But I also know that as new business owners, especially new business owners that don't have, big investors behind them and that are self-funding the launch of their business, they may not have the funds necessary to apply for the trademark. But once your business gets more up and running, as soon as you can apply, I think it's absolutely necessary, because the TM, the common law trademark, doesn't have any teeth behind it. But I do think that it can serve as a deterrent for people who do not know the difference between the registered trademark, and the TM. And I think that there's a lot of lay people who don't know the difference.
Yeah. Well, I mean, yep. It calls to mind some experiences with organizations that I've worked with in the past. And also, sort of in a similar vein, when you were kind of describing that scary situation of receiving a cease and desist letter and having to, not necessarily stop operations, but kind of erase your brand, to prevent something like that for a business that has several years of operations now under their belt, is building that customer base. Would you suggest that at this point, if you haven't already, to do that search and just kind of see where you stand with your brand and your logo, to take any actions, necessary ahead of receiving that cease and desist letter?
Yes, it's absolutely better to be proactive and to go ahead and face it head on, because if you do the trademark search, even though you're up and running and you learn through the trademark search that there may be a problem, and if you're concerned about it, you now have, you're not under threat of a cease and desist letter. Oftentimes they'll say you have 10 days over filing suit, or they may say 5 days, or they may say immediately in their letter. And so you don't have that rush to immediately go out and rebrand your business. You have a little more time if you know that an issue may be coming down the pipeline. Also, I want to point out one other thing. When we do the trademark search, we're looking for two things. Are there substantially similar marks? And if the answer to that is yes, whoever owns those substantially similar marks, do they provide substantially similar services or products as you? And so if you find that if you have a restaurant and you find that there's a company in another state, or even in the same state, it doesn't matter, that has the same name as you do, but they are providing, maybe they are architects. Well, even just because they have the same name, that's not enough to cause concern. It's not enough to be considered a trademark infringement, because certainly no one would come to your restaurant thinking that they were going to an architect. The services, you two are not competitors, and so the services that you provide are total opposites.
That makes sense. Yeah, that makes a lot of sense.
And one other thing that I wanted to mention is that if we have any listeners that are providing products overseas, or they have any dealings whatsoever in another country when it comes to their products, maybe they have them manufactured elsewhere, maybe they are trying to expand into a market somewhere else, it's critical for them to know that even if you have a registered trademark through the United States Patent and Trademark Office, that only matters in the United States for all practical purposes. Now, there are certain countries who will say that they will acknowledge those trademarks, and there's a whole, there's several countries that sign on to this treaty, and they say they will acknowledge them. But in reality, there are some countries who will, people will go over there and they will consult a manufacturer about producing their product. And that manufacturer will go ahead and apply for the trademark in that respective country. And that trademark will then be issued to them. In some countries, there's no requirement that you prove that you're using it. It's a first to file. You can file the application whether you're using it or not, and you can get the trademark without ever showing that you actually use it. And so we have some people that will expand into markets overseas, and they will eventually apply for a trademark themselves in that country, and they will learn that someone else already has it. And so if you plan on expanding your business or having it produced, parts of it produced in other countries, you really need to speak with an attorney about whether or not you need to apply for the trademark there before you introduce it.
Great. Thank you. So there don't seem to be any other questions at the moment, but you've provided your contact information here on the slide. I think that this was such a great overview of the really important topics to consider around your brand. Not always the most obvious, maybe, but I find, programming that we host here, particularly with, around issues related to small business law, just like you said, being proactive is always most important. It might not seem the most immediate, but in waiting, we can often end up with a much more expensive and complicated situation on our hands.
Absolutely.
Yeah. So thank you so much, Amanda. I really appreciate this. The recording and therefore the slides will be available to everybody on iConnect. And if there's, anything that you'd like to share as parting words, Amanda, feel free.
Thank you. Well, just thanks again for allowing me to present this webinar. And if there are any questions that come to mind, I find oftentimes, this is a lot of information and people may process it over a number of days. Maybe they sleep on it, and then in the middle of Saturday night, they wake up in a sweat, as entrepreneurs often do, and it dawns on them that they should have asked XYZ question, or they're worried about it. My email address is here at the bottom of the screen, amanda@jeltslaw.com. Feel free to just shoot me an email, and if I can answer your question, then I will.
Great. Thank you so much.
Thank you. Have a great day.
All right, everyone. Bye-bye.
Bye.